Jacob Cole Hogaboom versus Cheyenne Bill. Is it still? No, what's it now known as?
Fasig, Your Honor.
Could you spell that for me, please?
Yes, F-A-S as in Sam, I-G.
The petitioner appears self-represented pro se. Mr. Andrews has withdrawn from his case. The respondent appears and with counsel Rebecca Henry. The child at issue, I believe, is a female child that's approximately 7 years old. And there is a motion on file to modify parenting time. This is a 2021 case, 2021 DM 481. There has really not been a slew of filings in this case, but they have been exercising parenting, or he has been exercising parenting time that has become problematic with shared parenting time. So Ms. Henry has submitted some exhibits that she wishes the court to admit. But let's go ahead and start with your motion and what you're requesting the court to do and what you're asking for, and then I'll confer with him as to his position.
Thank you, Your Honor. And I understand the court has likely reviewed our motion, so I'll just kind of go through, try not to repeat myself too much. The parties do have Hayden, who will be 7 at the end of November. The court is correct. There has not been a lot of activity in this case. In fact, the last agreed order that was filed was June of 2023. So it has been several years since the parties have initiated anything with the court. I think that's important for the court to note because oftentimes when people come in with allegations, if they are repeat offenders in the court, I think sometimes that can be taken into consideration when you're looking at the level of conflict between the two parties. And the petitioner and the respondent here have worked fairly well together over the years and have maintained shared parenting time. The last agreed order filed in June of 23 gave them a week on, week off schedule. Exchanges are on Fridays unless there's no school, and then they exchange at 5:30. There were some additional provisions included in that agreed order back in 2023, given the petitioner's history with alcohol use at that time. Specifically, there were some provisions that required him to have a valid driver's license at all times. If for some reason it was suspended or revoked, the respondent was to receive primary residential custody of Hayden, and the petitioner would be subject to parenting time every other weekend. There were some additional provisions about if the petitioner was ever incarcerated, because he had had several arrests related to alcohol use, that he would be assisting with transportation. So all of those were taken into consideration given what was happening at that time. The petitioner was arrested for his 4th DUI, which we've included in our motion, 23 TR 1940, and was sentenced on March 21st of 2024. And I provided the court with a journal entry related to that case, which is our Exhibit 6.
All right, I'll take judicial notice of respondents Exhibit 6.
Thank you, Your Honor. I'm going to kind of go down the line here. Exhibit 7 and 8 are also related to the same incident. Those are both of his probation violations, one on August 19th of 2024 and one on March 7th of 2025.
Now, remind me, when the June of 2023 agreement was entered, had he already been charged with 23 TR 190, or did that come after?
No, I think he had, and Cheyenne can correct me if I'm wrong, nod yes or no. I think he had been arrested recently. Is that correct? Cheyenne, or no?
Okay, so those provisions that were set out were taken into consideration. That he had been arrested for 4th DUI, but he didn't actually have a conviction until after the agreement 3/21 of 24. But what has happened since that time is probation violations.
That's correct.
Okay, keep going. Thank you.
So the first probation violation was less than 5 months after he was sentenced, where the petitioner admitted to drinking alcohol. And then the second was in March of this year, where he failed to participate in mandatory treatment associated with his DUI. I would also point out for the court, this is a felony DUI. I know the court's aware of that, given that it's number 4, and carries with it some pretty significant ramifications. So beyond that, which my client has concerns about, she wasn't made aware of the probation violations in real time. She didn't know anything about them until months or even years after the probation violation occurred. So the petitioner has failed to inform her of that. Now, of course, there's nothing that requires him to let her know that he's had a probation violation, but she likely would have initiated an action earlier had she known even about the first probation violation when it occurred back in 2024. But she just wasn't made aware of it at the time that it occurred. So here we are now, you know, in 2025, filing a motion asking for these changes. My client received communication from the petitioner's significant other. He and significant other recently had a baby together. Her name is Haley, and those are in Exhibit 11. And the petitioner, the respondent, and respondent's significant other all know each other. So they have previously run in the same social circles. My client is friendly with Haley is her name. And so they had established a friendly relationship even prior to her getting in a romantic relationship with the petitioner. So in August, so just a couple of months ago, the petitioner's significant other reached out to Cheyenne, to Respondent, about concerns that she had about the petitioner's continued alcohol use. Page 2 of that exhibit, she tells my client that she has thoughts about calling his probation officer, but doesn't know that it would do any good. She has on page 3 provided examples specifically of him drinking where he's missed major events. Her sister's baby shower. There have been events for school that he's missed. Page 4, Haley talks about how she cannot trust him to stay at home with the children. She has children from a previous relationship. Obviously, the petitioner has Hayden, and then she just recently had a baby that is the petitioner's as well. So there have been multiple instances where she said that she can't leave the kids home because she doesn't trust him.
Okay. It looks like most recently he's lost his job. So Mr. Hogaboom, you have seen all of these things and texts, and you're aware of your probation violations and your alcohol issue. And I don't know the status of the Red House or your movement, but if you don't have employment, that's problematic. So what is going on with you in relation to treatment? This is not a shared custody situation anymore. This is not a workable, safe shared custody situation the way it currently exists.
I'm, excuse me, I'm self-employed. I'm hoping to get a pumping job. I was offered. They have 2 more people to interview, but it's looking like I might get it. And it'd be for Vess Oil Corporation. opportunity of a lifetime, but
Who?
Bess Oil Corporation,
Can you
they
spell that?
BESS.
Okay.
They
How
called me,
were you related to Albert Hogaboom?
he was my uncle.
Okay. All right. So Kathy,
Was
that
my
I learned recently passed away. She
She
was
did.
not your mother.
No, she was my cousin.
Okay. So you resigned from Hogaboom, which you had no interest in. You were just an employee.
Yes, ma'am.
How long did you work there?
Almost 7 years.
Okay. And who are you currently living with?
Haley. We have a house together in El Dorado.
And it's not this red house out of town.
No, we moved out of that because it wasn't getting done like it was promised and we needed something better.
Okay. Are you renting?
Yes.
And where does your daughter attend school?
Ewalt Elementary in Augusta.
And what's your probation status?
I'm still on it for until March, I think. March or April.
So it was extended to 2026.
Yes.
And are you on community corrections?
Yes.
Okay. Who's your ISO?
Danny McKenzie.
Okay, yeah, I think I saw that on the voluntary sanctions that you've done. What is your treatment status?
It's active. I go once a week.
Where are you going?
ARC. It's in Augusta, ARC.
Okay. Do you have a valid driver's license?
Yes.
Can you provide proof of that to Ms. Henry, please? Or give her the information so she can go online and look at it?
Oh, yeah. Let me get it.
I don't want you to give it over the
Oh, okay.
broadcasting.
Email or something.
I need you to email it to her. Do you have access to a computer that you can email?
I can once I get home. We're on a field trip right now. Or I can do it on my phone, I guess.
And Your Honor, I would be interested to know that because I think the court has seen our exhibits show that there was a ticket just last month and a summons related to a suspended driver's license.
That was back in March. I didn't even know it was suspended because I still had it. And when he pulled me over, I still had the actual license, and he said the paperwork saying it was suspended probably got sent to an old address. And that was why, but I got it back in July, I believe.
Do you have an interlock device?
Yes, I do.
Okay, well. Yeah, I'm just not sure about this week on, week off, until things calm down with you and you've completed treatment and you've got a regular job and some stability. So are you, objecting to, reducing your parenting time with mom having primary residential custody?
I mean, I'd like to, but I don't have an attorney, so I don't really have a leg to stand on.
Well, no, you can represent yourself, but I just think things have gotten chaotic and a little too far out of control.
I understand.
And I do want confirmation that you have a driver's license, because if you don't have a driver's license and you get stopped and they arrest you because it's an arrestable offense, then they're gonna take her into custody. Plus, she's gonna see the traumatic
Yeah, I understand.
actions of you being handcuffed and put in a police car and all that kind of stuff. So that's why that's so significant, to make sure that you're not responsible for driving with her on a suspended license. So that has to be verified for sure. And you got to get treatment completed, and I've got to get a record from them that you've successfully completed. And then I think that sober link will make a difference for a while. Ms. Henry, I mean, you can't look at somebody and judge them, but it doesn't look like to me he's real strung out. Or that he's actively using daily. When was the last time that you consumed alcohol?
Probably last Thursday, I think.
Okay, well, you're
I'm being-
still using. You can't use and be in treatment just to get through treatment.
I understand.
You're on a fourth DUI. They are now felonies where you go to prison. There's no more county jail time, and you're gonna be stuck in a county jail for 90 days or 6 months or 30 days or 5 days. You go to prison. You're going to go to prison. That means you can't control your drinking. That means, and you don't have good judgment when you drink. That means that you're an alcoholic. That means that you cannot drink at all. Not one drink, not one beer, not one shot, not anything ever again. And I'm guess you're not getting that message in treatment. You're not accepting that. So I'm going to grant their modification request. What's your parenting plan proposal? Where do I find that? Right here on Exhibit 3.
Yes, Your Honor.
And frankly, I'm not calling you a bad guy. I'm not saying that you're a bad guy or a bad father or anything else. But mom would be remiss not to protect her at all levels. And if something happened, she wouldn't be able to live with herself. So, like I said, I have faith that you can turn things around, but I have to see evidence of that.
Understood.
So she wants to go to every other weekend. And you have to sign up and participate over those weekends, because she's not asking for supervised. She's not asking to terminate until things happen. She is giving you the benefit of the doubt and the benefit of visitation, is what she's proposing. And I think it's reasonable that you participate in Sober Link and have every other weekend. You obviously can attend any school activities or anything else that she's doing. And I need a letter from your alcohol and drug counselor as to where you are in treatment.
Okay.
And when it's contemplated that you'll be done. And it sounds like to me, if you're still drinking, you need to up your treatment.
Okay.
I really am concerned about you not only going to prison on this case that's you're still on probation with Judge Hardon, but I'm concerned that if you picked up another one, and it doesn't matter if it's on your non-parenting time and you drink and get a DUI, that you're gonna end up in prison. So you've got to stay sober, you've got to secure good employment, and you've got to work on yourself. And that's what you need to do with any free time that you have when you don't have your daughter. I have no doubt that you love her. Alcoholism isn't about who you love or who you don't love. It's not, it may be related to selfishness, but that's part of the addiction as well, but it's not a lack of love. But again, there needs to be some level of protection. There needs to be some level of accountability by you. And so I'll review the case in 6 months and see where you're at. See if you've completed your probation, off probation. See if, you have, positive counseling records. Now, before that though, I want confirmation of a valid license and that you're in treatment.
Okay.
And then you're participating. And then we'll review it when your treatment should be completed. You should be discharged from your probation. You should be compliant with SoberLink and have employment, and we can revisit the parenting plan. Who are your parents?
JR and Sheila.
Do you tend to have difficulty during the holidays with refraining from alcohol use?
No.
What did you propose, Miss Henry, on the holidays?
Your Honor, we have listed, just passed through it here. In our motion, essentially, we had the same holiday schedule, except that, if there would normally be an overnight, it ends at 8 p.m. On the first day of the designated holiday, and then it resumes the next day at 8 a.m. So there wouldn't be an overnight, where my client would disagree. I think that there are a lot of holidays that the petitioner's family and I mean most families, just there's alcohol around, and it happens later in the evening. So she tried to give him as much time as possible with the holiday ending at 8 p.m. And if it is a holiday where there's more than one day, Hayden would go back to Miss Fasig, and then she can drop her back off at 8 a.m. the next morning.
Okay, well, I'm gonna allow that for Halloween and Thanksgiving. And then I want an update. I don't know about Christmas. But I certainly can add Christmas if it appears that's what's necessary. So
Understood, Your Honor.
maybe, I mean, so you're just gonna have to request an immediate hearing on the issue of Christmas if they can't agree.
Okay,
If mom feels like it should be restricted and they can't agree, you're gonna have to do a quick Christmas holiday break
okay,
deal. Hopefully it will be more reassuring for mom with this SoberLink that visits are going well and overnights, and that he can earn some
understood. Yes,
more
Judge.
overnights through that it'll be a positive thing and not end up being negative. So I've adopted 2A. I have adopted 2B because I think that's the standard sobriety link requirement. I C, I'm modifying to, I want a current report and a prognosis.
Okay,
I mean, you don't get to your fourth DUI and have probation violations unless you have an alcohol dependence issue. And so, I don't know that what evaluations he has. I don't think I'm gonna require that they be produced, but I think that she's entitled to have confirmation that he's in treatment, that he's participating. And, when it's projected to be completed.
okay,
And then, Mr. Hogaboom, I would suggest that you speak with your counselor about the fact that you consumed alcohol as recent as last week. Because I have a feeling that she is, or he is, going to increase your time in treatment. And as I indicated, you will have more free evenings if you don't have your daughter every evening of a week. So you can commit to that. Because I wouldn't call once a week necessarily intensive treatment, and that may be what you need stepped up to.
Yes, ma'am.
Only transportation with valid license D and the breathalyzer in the car.
Yes.
And, then we'll review the case in 6 months. And I have now, she believes their daughter should be in therapy.
yes, I think that part of the reason we were asking for therapy was kind of to assist, because this is gonna be a transition. So kind of to be able to assist with the change. But also, given what my client has discovered, we just want to check in and make sure that there isn't something else that the child, something that's happened that we don't know about. So just giving the child a neutral outlet, to be able to talk with somebody who's not my client. It doesn't have to be for purposes of the court. We're not trying to, gain leverage or anything. So,
Well, I mean, I'm not gonna order therapy. I think that a parent can enroll their child in therapy without a court order. They can take their child. They just have to notify the other side and put the other side's name down so the other side can get access to records or information or participate. But I don't think that even with joint custody, which I'm not gonna change legal custody to sole or anything like that, but with joint custody, I think if either parent thinks it's in the best interest, they have the right to do it. And then I suppose if some parent objects to it, they can come to court and try to get a prohibition against it from a judge, but I don't, she is free to do that, play therapy or whatever she thinks is appropriate based on her observation of her child's needs and if she's seeing any regression or any concerning behaviors from her.
Okay.
So. And Mr. Hogaboom, if you are an adult child of an alcoholic, you know there are a lot of effects on children that live with good parents. For the most part, they're just alcoholics. And there's scarring that occurs from that. And so I don't want you, again, thinking that you're just being personally punished, but your actions, your activities, your state of mind, your recovery does impact her, whether you think it is or not. So Okay, and I do find that this modification is at this time in the best interest of the child. And I'm going to review. Now, I sure hope, I know you said the parties know each other, but when I looked at some of those text messages, your client kind of promised she wouldn't tell anybody, and his wife was confiding in her, and I don't know that she's going to continue to do that. But I am going to say there should be no retaliation of any sort because of what's been brought to the court's attention. I just, with all of it, I just don't think someone would be a good parent if they didn't at least address the elephant in the room, which we are doing right now. So, all right, October, November, December, January, February, March, April. We're going to review this in April. His probation scheduled to terminate in March, and that would be April of 2026. And as I indicated, if there is something in between that comes up that needs to be addressed by the court, you can just, because this is, well, I want to say that I've entered this temporarily. I don't know that I won't adopt it as a permanent order. I may still find that arrangements is what's best for her. But I'm going to consider this an open motion for purposes of you to be able to request a hearing on anything related to these issues that are before the court.
Okay.
So how about April 13th? That's a
Sounds good to me,
Monday.
Judge. I don't have anything out that far, so April
Okay.
13th sounds great.
Okay, you want to review it at 1?
Sure. Will that be in person or by Zoom, Your Honor?
I think we can do Zoom unless you request in person. My printer didn't print for some reason, but the new rule on audio visual has come out by the Supreme Court. So you might take a look at that. You have a right to request in-person hearings, and there's kind of a protocol of consideration for the court.
Okay.
So, but I'm gonna schedule it Zoom.
Okay. Your Honor, I did want to clarify one thing. My client just so the record's clear, and I don't know if this is substantive or maybe this makes it even even better. I don't know, but my client said that she and Haley did not become friends until after she started dating the petitioner. So they didn't know each other immediately before, they knew each other and became friends after. So not that makes a huge difference, but I just, for the record and to make sure my client didn't want to misrepresent anything, and I certainly misunderstood that. So just
Okay,
to clarify.
okay. Well, might have been my bad, but at any rate, I would hate to see all communication being destroyed because of
Sure.
his disclosure. And because I do think that everybody's intending to act in good faith. So
Yes, Your Honor.
I'm not sure what interestingly enough, in your motion, you didn't ask for child support, did you?
No, Your Honor, we did not. My client's just asking, given the, we weren't sure what was going on with petitioner's employment. She's not asking for child support. She's just asking that the petitioner be responsible for the SoberLink costs. So,
Okay. Well, Mr. Hogaboom, frankly, she's entitled to get child support from you if you're not sharing expenses because you don't have equal time. But she has indicated that that's not what she's seeking right at the moment. And so, that could be something that could be looked at down the road. But if you do obtain new employment, you need to notify Ms. Henry of where you're working so that she can access income information to do a worksheet, because she has to always give legal advice to her client, even if her client wants to waive seeking something. She needs to be able to tell her client what she's waiving, and keep up to date with the case, since she's the retained attorney. Also, if you get this job that you really want, that sounds like it may be beneficial for you, will it involve working out of town, out of state?
No,
Okay. All right, so make sure that you put that Monday date, that April
13th.
13th down at 1 o'clock by Zoom.
Yeah,
Like I said,
I
go
wrote
ahead.
it. I wrote it down already.
Okay, thank you. And like I said, if something else occurs, then you need to contact the court, get a court date, and notify the other side of a notice, give the other side a notice of hearing. Otherwise, unless you receive a notice of hearing, I won't see you again until April.
Yes, ma'am.
All right, very good. Any questions?
How do I do the sober link thing?
Can you send him some information, you two exchange the emails and give him the enrollment information?
Yes, Your Honor.
Okay. So you can get that from Miss Henry. She'll
Yes.
provide you with all of that. Okay,
Yes,
all
ma'am.
right. If there's nothing further, we are adjourned.